are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about trust and estate administration, estate planning, and all matters in that realm, whether it's both from the standpoint of your own estate planning, but also if you're a professional like me who helps people with these matters. And so today, I'm going to talk about the role of the judge in a probate court. Now, I practice specifically, or my main location, I guess I should say, is California. And that is the jurisdiction that I'm most familiar with. However, I have dealt with matters in Alabama, for example, and some other jurisdictions. And I find that, I found at least so far that most probate courts tend to have jurisdiction over the same types of cases. However, your location, it might be a little bit different than what it is here in California. Nonetheless, we're going to talk about this in a somewhat general way with respect to location or venue. So, probate courts basically handle, I guess, two categories of issues or matters, if you will. One is managing probates, the process of an estate working its way through a court and the whole probate process. Now, that may be because the decedent left behind a will, as opposed to a trust, which would mean the estate doesn't go through probate, or because the decedent died intestate, and so there is no will, there is no trust, and so that person's property, that person's estate, is going to get dealt with according to the laws of the state in which the person was a resident. So that's one category. The other category is the other category is the managing of guardianships and conservatorships. Okay, now those aren't the same thing, but they are somewhat similar. So guardianships are when a minor, generally someone under 18 years of age, is put under the custody of the court for that child's or that minor's well-being. Okay, now the guardian would typically be court appointed, and that person oversees matters for the welfare of the minor until that minor reaches the age of majority, again, generally 18 years old. Okay, at which time the guardianship may or may not be dismissed. Okay, and then there's a conservatorship. So a conservatorship is when an adult is essentially put under the jurisdiction of the probate court, typically for the reason that adult is not able to handle his or her own affairs. Okay, so you could have a person who's elderly and is no longer able to handle her affairs, or you could have someone who is disabled and as a result of that disability is likely to be taken advantage of. And so is that person is put under conservatorship by the court. And again, the court would appoint a conservator. Now, just to give you a little background, in my first career, right? And those of you who watch the show often enough, you know that this is Kevin 3.0. So in Kevin 1.0, when I had my commercial real estate services company here in LA, one of my clients for many, many, many years was the Jewish Family Services conservatorship program. And this was part of Jewish Family Services is a social service agency connected with the Jewish Federation of Los Angeles. They dealt a lot with Jews who needed to be under conservatorship, but they were non-sectarian, so it wasn't only Jews. Their services were available to anyone who wanted them. And I dealt with quite a number of cases, both as a property manager. So there were situations where typically a property owner had gotten so old she was no longer able to manage the building herself, and so her affairs were put under a conservatorship, and then JFS, Jewish Family Services Conservators, I was their sort of third-party property manager. So when they had a situation like that, they would call me up and I would take over the management of the property. Now, oftentimes the owner of the property lived in the building, and they were reluctant to move. I use her because most of the cases we dealt with were the conservatee, the person put under conservatorship, was a woman. So you had oftentimes a very elderly woman, but she was still living in the building. And so part of my duties was to just, periodically make sure that she was okay, and, make sure that her unit was kept in good repair, just like all the other tenants in the building. And so So in both a guardianship case and a conservatorship case, the court appoints someone to oversee the affairs of an individual, and then the court manages those guardianships and conservatorships. Okay, so those are the two categories. Again, managing the probate process. Okay, whether it's a will being probated or an intestate probate, and managing guardianships and conservatorships. Okay, so those are the two main categories. So I'm going to talk about what the judge does in probate first. Okay, so number one, the judge is responsible for for overseeing the process of validating a will. Okay, so what typically happens at the beginning of a probate, assuming that a will exists, is that will is presented to the probate court for probate, and the appointment of the executor in the will as the administrator or personal representative of the estate. Okay, now that's assuming that that executor is able and willing to serve. If for some reason the executor is unable or unwilling to serve, so then someone may be nominated in that person's place. There may be a successor executor named in the will, or there may not be, in which case typically whoever is submitting the will for probate will nominate someone to handle that. Okay, it may be another family member, it may be a professional like me, it may be an attorney. It really just depends on the situation. Okay, and it's up to the judge to oversee that process and make sure that the will meets the legal requirements, okay, such as it's properly signed, it's properly witnessed, it was not fraudulently created, okay? And, you might be surprised how often these issues arise in the probate court. So I'm dealing with two cases right now where in one case, after 3 years, the court held that the will that was submitted for probate was indeed fraudulent. Okay, and so now we're dealing with the aftermath of what's going to happen there. I'm dealing with another case where the decedent died intestate, and now it's actually a child of someone who was connected to the decedent is now seeking to have a will submitted for probate, so that and is wants to be named as the administrator so she can take over the administration of the estate. Interestingly enough, it's the same law firm who's representing the party in both of those instances, and so it's up to the court to decide whether a will is valid and therefore will be accepted into probate, and then the appointment of the executor or the administrator. These days, you'll hear the term personal representative used, and that personal representative can be either an executor or an administrator. So an executor is someone appointed under the will by the maker of the will. An administrator is someone appointed by the court who was not named as an executor. Both of those are forms of personal representatives. Okay, so the other another duty of a judge in probate is to resolve disputes. So the judge will hear challenges to the will, okay, such as somebody may allege that there was undue influence on the maker of the will, and that had that influence not been there, the will would have been written differently or may not have been written at all, or that the maker of the will lacked capacity, meaning that they didn't really know what they were doing. Maybe they were very sick at the time the will was purportedly signed, or maybe they had lost mental capacity. Maybe they were suffering, let's say, from Alzheimer's or some sort of dementia or some other mental impairment, and so somebody used went and got them to sign a will anyway, and in so doing, the will would be fraudulent because the maker of the will did not have the capacity to establish that as a legal document. Okay, there's also allegations of improper execution. So wills need to be signed by the maker of the will, and typically also by witnesses, usually two witnesses. I think it varies from jurisdiction to jurisdiction. Okay, but certain parties in certain jurisdictions are excluded from being witnesses. So sometimes family members are excluded from being witnesses. So if you're in a jurisdiction where that is the case, so if a family member was one of the witnesses, it may be that the will was not properly executed. And so the judge, and there may be a dispute about that. And so the judge would have the responsibility for resolving that dispute. So let's use a situation where a will was drawn up and somebody signed it, and then maybe down the road the maker of the will and the person who signed it got married, right? So now that person is a family member. I could imagine a situation where if somebody didn't like the terms of the will, they might challenge the execution of the will based on one of the witnesses now being a relative. Okay, or you might have a situation where an ex-spouse witnessed a will, and that also raises some suspicion depending on what the relationship is between the spouses. Did they have a cordial relationship? Did they have a contentious relationship? And if the will is giving property to the former spouse, what was there some undue influence there? Is that proper execution? So these are all types of issues that can be raised in the contest of a will, and basically the number of issues is only limited by the creativity of someone who wants to contest a will. That doesn't mean that there's legal validity to all of these issues, but the court would still have the responsibility of hearing the matter. And frankly, even if it's patently frivolous, the court would still have to schedule a hearing, hear the matter, and then in the case of a frivolous contest, would likely rule the petition denied with or without prejudice. I'll mention what that means in a minute. But in any event, no matter how spurious a claim is, the judge has the responsibility for getting to the facts and making a decision. Now, just as an aside, when a judge in a probate court, or for that matter, typically any court, makes a decision about a matter like a petition, that's typically what you do in probate court. They can deny it with or without prejudice. When they deny it without prejudice, what that means is the petition can be refiled if there's new information found to support the refiling of the petition. If the petition is denied with prejudice, that means the petition cannot be filed again. Okay, that means the matter is solved and that's it. Now, in my experience, I haven't seen a situation where a probate court judge denied a petition with prejudice. I think they always want to keep open the possibility that new information will be found. And so there's no point really to denying a petition with prejudice. I'm not saying it never happens. It just hasn't happened in my experience. But so most likely a petition gets denied without prejudice, and that way the party can go on to refile if there's some new information found, some new facts uncovered. Okay, so resolving disputes is another responsibility of the judge in probate court. Okay, I mentioned appointing executors or administrators, personal representatives. Okay, so, and I mentioned the conditions under each of them. And the executor, the administrator, has the responsibility of administrating the estate. Now, you will hear some personal representatives and other parties in probate say that the administrator or the executor manages the estate. That's not strictly correct. Okay, so for example, if the estate has real estate in it, okay, real estate typically has to be managed. Let's take an example of an apartment building. That's a real simple one, right? Rent has to be collected from the tenants, bills have to be paid, maintenance has to be done, et cetera, okay? That is, the managing of that building is not part of the routine duties of a personal representative. And normally, a personal representative will hire a property management company to manage that apartment building. Okay, now some administrators have that ability in-house or may choose to do it, in which case they will typically qualify for what are called extraordinary fees. So I think I've talked about compensation in probate in one of my previous shows, but just real quickly, in a probate, the fees that the personal representative gets are set by law, but those fees are paid for certain specific work that the administrator does. Anything outside of that scope entitles the personal representative to extraordinary fees. And so that's why I emphasize this word administrates the estate, not manages. Management functions generally are beyond the scope of what a personal representative is brought in to do, whether it's managing a portfolio of securities, managing property, managing a business. All of those are outside of the routine scope of the administration of an estate. Now, the administration of the estate will require that the personal representative see to it that assets are managed properly, but that doesn't mean that the personal representative is responsible for doing the management himself. Okay, so I want to be clear on that distinction, because that's really what's going on here. Okay, and with respect to the court and the judge's authority, the judge is responsible for overseeing the estate administration, i.e., what the personal representative is doing. Okay, so the estate administration basically amounts to finding all the assets, gathering them up, finding all the debts, gathering them up, paying the debts, and then distributing the remainder of the estate according to the terms of the will, or if there is no will, according to the laws of intestate succession for the particular state in which the will is being probated. Okay, that is the function. That is what the personal representative, the executor or the administrator, is charged with doing. Now, notice that nowhere in there does it say manage the assets of the estate. Okay, that is not part of the administration process. It's the overseeing of the management that the administrator is responsible for. Okay, so the court would only indirectly oversee the management of the assets of the estate, only through the effective administration of the estate by the administrator. Now, you may be saying, wow, that's kind of a distinction without a difference. Not really. Okay, so typically the administrator is not going to be submitting monthly reports on the management of property to the court. That's not what the administrator is going to do. Okay, and even in a final accounting, depending on the situation, the administrator may not be reporting on the management of the assets per se, only the results of the management of the asset, i.e., the net income from this asset was, X, Y, or Z. Okay, and especially if those real estate is the easiest one to see this with. Let's say those assets are owned by entities. So let's say each property is owned by an individual LLC. So the management of the property within the LLC is not something that the court is really going to be concerned with per se. It's really only the administration as it relates to the management of the LLC that the court is going to be concerned about. Okay, so keep in mind that distinction between administration and management, because the court's authority is over administration, it's not directly over management. Okay. Finally, the court is responsible for certifying the final estate closure. So the personal representative will typically have to submit a final accounting of the estate to the court, unless it's waived. Okay, now the beneficiaries do have the right to waive a final accounting. Okay, and sometimes they will, and sometimes they won't. It really depends on the particular circumstances. Okay, but in sort of regular procedure, the personal representative, will submit a final accounting. Okay, and that final accounting shows all the assets, the income, and the expenses incurred by the estate during the probate, and basically shows that all obligations have been fulfilled, all debts have been paid, all taxes have been paid. Okay, and that all the remaining assets have been distributed to the beneficiaries. Okay, and then the judge has the responsibility to see that all of that has been done properly, and now the judge orders the estate closed. Okay, or orders, I should say, not the estate, orders the probate closed. The probate is the court action, which the judge has cognizance of. cognizance over. Okay, so in the managing of a probate by the judge, those are the areas where the judge gets involved. Okay, now with respect to managing guardianships and conservatorships. Okay, so as I mentioned earlier, these are situations where you have an incapacitated individual or a minor or a vulnerable party, and making sure that they're not taken advantage of, that their affairs are handled properly, etc. Okay, so and I mentioned before, again, a guardian is appointed for a minor. A conservatorship is basically appointed for an adult who's unable to oversee their financial or personal affairs. Okay, now the court appoints the guardian or the conservator, and then oversees, monitors that individual. They will typically be responsible for reporting to the court periodically about what they've done, about what issues have arisen, how they've been handled. Okay, and the court will in general be responsible for ensuring that the guardian or the conservator fulfills his responsibilities. Okay, now conservatorships can be broader or narrower. It depends on the circumstances. Okay, and so it's hard to go into the details because they will vary considerably depending on the situation. But they will typically, the kinds of things that are handled within a guardianship or a conservatorship is financial matters, the booking of income, the paying of expenses, the maintenance of assets, the payment of debts, not unlike what you hear about in probate. So the same kind of activity. The difference is that in a probate, it happens just while the estate is going through probate. For a guardianship or a conservatorship, it happens as long as that guardianship or conservatorship is in place. And that could be for years. It could be for the rest of the life of someone under a conservatorship until that person passes away. And now at the point where the person passes away, the conservatorship will end, and now there will be a process of dealing with the person's estate. Either if the person had a trust, so it will be the administration of the trust, or if the person had a will, then it will be a probate, like I talked about just a few minutes ago. Okay, with a guardianship, that guardianship may end when the child reaches the age of majority, typically 18. However, again, as I mentioned before, a guardianship could, in essence, be converted into a conservatorship after the child turns 18 if the child is still unable to handle his own affairs. And just like with a conservatorship, the matters handled in a guardianship are not necessarily just financial matters. They could be personal matters, such as schooling, such as social activities. The guardian basically steps into the role of a parent. And now sometimes a parent will be appointed a guardian, other times not. But in any event, typically a guardianship and a conservatorship have cognizance over a broader array of issues than purely financial issues. Okay, they're there to protect the vulnerable party. Okay, that's the key thing to remember. And when the court monitors a guardianship or a conservatorship, that's what the court is going to be looking at. Whatever the extent of the issues are, the court will be reviewing them and making sure that they're being handled properly. Okay, so is the child progressing in school? Is the adult being properly taken care of physically? Are their healthcare needs being met? Physical healthcare, mental healthcare. It is part of the part of the conservatorship, making sure that the person gets to worship services so that their spiritual welfare is being taken care of. All of these things can be part of what the judge oversees or monitors with respect to a guardianship or a conservatorship. Okay, so that's the second category of matters that that a probate court judge has cognizance over. Now, there are some issues that the judge oversees and that are the same for both types of matters, and I just want to talk about those for just a few minutes here before I wrap up the show. So again, one of them is addressing disputes. So beyond a dispute over whether a will is valid, there are myriads of opportunities for disputes to arise in a probate or in the case of a guardianship or conservatorship. So I handled a conservatorship one time, or I didn't handle a conservatorship. I was not the conservator. I was involved. This was a conservatorship handled by Jewish Family Services, where the conservatee, the person under the conservatorship, needed some significant healthcare services and did not have the cash to pay for them. Now, the woman had other assets, but the way her will was set up, it was in such a way that if one asset was sold, that heir would lose out on his inheritance. If the other asset were sold, that heir would lose out on his inheritance. And so even though their mother was still alive, they were already fighting over what would be sold in order to see to it that their mother was taken care of. Now, aside from that being disgusting on a human level, that these children are fighting over money, and in the meantime, their mother needs health care, the court was charged with figuring out was charged with addressing that dispute and figuring it out. And now, as I'm telling you this story, I don't recall what ended up happening. I think the court decided that some of the stocks and bonds would be sold because that wouldn't completely disinherit that party, while selling the house would have completely disinherited the other party. I think that's what it was. My suggestion was that there be a negotiation between the beneficiaries of the will and an agreement that, notwithstanding what the will said, that they would share 50-50 in whatever was left in the estate at the time of their mother's death. And that way, that there wouldn't be a sort of ongoing disputes about, what money was going to be used in order to care for the conservatee. That was the recommendation I gave. I don't know. I don't recall now if they tried that and they couldn't get them to agree, or what exactly happened. But in any event, it was the court it was the judge really that had the authority to address that dispute and in the end decide what was going to be done. Now, it's not that the conservator didn't have the authority to sell one type of property or another. Sometimes a conservator or a guardian, or for that matter, a personal representative, will have the authority to do something, but because there is a dispute, they will submit it to the court to get the court's okay to do the action that the personal representative, the guardian, or the conservator wants to do, so that down the road, there's, if a beneficiary, for example, questions that, the personal representative, the guardian, the conservator can say, well, I submitted it to court approval and the court ordered this, and so I did what the court ordered. Okay. And for people like me who do this professionally, in a number of cases, that may very well be the best solution, so that although we have the authority to do something, we don't get ourselves and the estate or the guardianship or the conservatorship into trouble down the road because someone doesn't like something that was done. Okay, so that is the sort of dealing with disputes is something that probate court judges have the responsibility to do no matter what the type of matter. Okay, the next thing is interpreting and enforcing laws. Okay, so there's an entire probate code here in California, as there is, I think, in most, if not all, the 50 states. And it describes what is the basis for the handling of these matters. Okay, so how will a will be probated? How will an intestate, the estate of an intestate decedent be handled? How will guardianships and conservatorships work? So the judge is responsible for seeing to it that the law is enforced. Now, these are not criminal laws, okay? These are civil laws, okay? Nonetheless, they still need to be enforced, just like the laws of contracts need to be enforced, et cetera, okay? And it is incumbent on the judge to know the law. Okay, now if the judge isn't familiar with the law, the judge has to get familiar. That's why you will sometimes see in petitions and that are submitted that the lawyer drafting the petition will quote various statutes, whether they're probate or whatever, that are relevant in case the judge is maybe not familiar with that statute or needs a refresher, something like that. So the lawyer, it's the responsibility of the lawyers to bring to the judge the relevant statutes that what I should say, the relevant statutes. Okay, the statutes that on which the particular matter or issue hangs. Okay, now it is not the responsibility of the lawyers to bring to the judge's attention statutes that don't make their case. And this is why it's important for the judge to have a thorough knowledge of the probate code, okay? Because just like in any court proceeding, especially if it's a dispute, the lawyers are there to advocate for their clients. The lawyers are not there to see that justice is served per se. The way lawyers serve justice is by advocating as competently as possible for their client as they can. And then it is up to the judge, since there are no juries in a probate court, it's up to the judge to decide where justice lies. Now, having said that, it is not at all uncommon to see what I would call miscarriages of justice. Oftentimes, the judge is doing what is expedient, and if the judge doesn't perceive that there's significant enough damage to worry about it, the judge will frankly ignore what is just in a particular case in order to move a case in order to move the calendar along. In other words, get cases heard for that day and get done for the day. Okay, so interpreting and enforcing laws is another responsibility of the judge in probate court. Okay, and then finally, and as I've talked about already, approving financial decisions. So, as a matter of course, the judge in a probate has the duty to review and approve the final accounting. In guardianships and conservatorships, the judge has the duty to monitor the reports submitted to make sure that everything is being done properly. Now, oftentimes, it's not the judge who's doing the detailed monitoring. There are what are known as probate attorneys. These are lawyers who work for the probate court, and they do the the more tedious day-to-day work of the court and then report to the judge on their findings. Some judges rely more on the probate attorneys than others. I suspect, I don't know this for a fact, but I suspect some judges will rely more on certain probate attorneys than other, as those ones being, more reliable in the reviews that they do, the advice that they give, etc. Okay, so again, the two major types of matters over which the judges in probate courts have power are probates and guardianships and conservatorships. Okay, those are the two types. And the judge is there to deal with the law, make sure it's applied properly, deal with disputes, make sure those are resolved, oversee the process, whether it's the probate or the guardianship or conservatorship, and finally approve financial decisions and make a decision as to whether and when a guardianship and conservatorship should end, just like the judge decides, when makes the final decision on closing the probate. Okay, so as I said, that is the role of the probate court judge, and some are better at it than others. Frankly, some have more experience than others. I'm dealing with a very, very experienced judge in Alabama. He's actually getting ready to retire soon. It's going to be a big loss to the Jefferson County Court. And I've dealt with some very inexperienced judges here in California. And you can see, if you were a party to the proceedings, you would see a vast difference in how things are handled. And it's a shame, but that is the reality of the court system under which we're operating these days. So if you have any questions, comments, please drop them into our social media. All the links will be in the show notes after the show posts. And if you have any questions of a more personal nature, my email address will also be in the show notes. Feel free to send me an email, with the caveat, as always, that I will respond if it's within my area of knowledge. If not, I will make a recommendation that you get, legal advice, or you get accounting advice, or whatever it is. And if you need a referral, I will be happy to make a referral if I have one for you. Okay, so that wraps it up for today. By the way, since I mentioned my YouTube channel, if you are not already a subscriber, I'd really appreciate it if you would consider subscribing. I'm looking to get to 500 subscribers. I'm pretty close now. That's the minimum number that I need in order to qualify for YouTube's monetization program. So I'm very, very close. In fact, here I'll give you the number. And the number is, I'm at 461 subscribers. So I need 39 more subscribers and I hit my goal. So if you're not already a subscriber, again, I'd really appreciate it if you consider becoming one. And that way you'll get notified anytime a show goes live, and you'll know, and you can join us live, or you'll know to come visit the channel and watch the episode there. By the way, you can also watch episodes now on Spotify and Apple Podcast. Okay, so I'm not able to stream live on those outlets, but I do upload them, generally speaking, within an hour or a few hours of a show. And once they're up on Spotify, I think within 24 hours, they are also up on Apple Podcasts. So wherever those are the three largest video podcast platforms. And so wherever you prefer to watch your shows, hopefully I'm there for you. So tomorrow at 10 a.m. Tuesday is my show, Business Lessons from the Military. And I'm going to be talking about, I believe it's 5 important business lessons we can take from the career of Lawrence of Arabia, the famous Lawrence of Arabia, otherwise known as T.E. Lawrence. a fascinating character in military history. So I hope you'll join me for that. And then on Wednesday at 10 a.m. is this month's Economic Echoes, where we'll talk about what's happening in the economy and how it affects us as individuals. And then on Thursday is my every other week show, Jiggers' Place. It's at 5 p.m. on Thursday. Again, all of these times are Pacific time. And I'm going to be taking you to the South Seas for a Tahitian breeze cocktail and talking about one of my favorite books of all time, Mutiny on the Bounty. I've read that book countless times now since I was a kid. And so as we head toward the end of the week on Thursday afternoon, a little journey to the South Seas, and again, Mutiny on the Bounty. So, and then, of course, a week from today, I'll be back with the next edition of the next episode of Trust and Estates Weekly. So I thank you so much for joining me, especially those of you joining me live. Always great to see the little number ticker up here in the corner. And wishing you a wonderful rest of the day. Signing off, Marie, darling, you are